Good afternoon, everyone. My name is Kate Walls. I'm the Executive Director of Uptown People's Law Center. Welcome to our webinar, Fighting for Your Civil Rights in Prison, featuring our new Prisoners' Rights Guides, and my Howard and Alyssa Meurer. We'll get started. We should have 10 to 15 minutes at the end for questions. Feel free throughout the webinar to put your questions in the chat. Thank you.
Hi, everyone. Thanks for joining us. This is Uptown People's Law Center. This is one of our first webinars of a series that's yet to come. I am new to this, and I'm so excited to share what we do here at Uptown People's Law Center. We are an organization that's been fighting for prisoners' rights for a long time, 45 years, that I know of on the inside. And we are a Chicago-based legal nonprofit organization that works with communities impacted by systemic oppressions of the criminal legal system to restore human and civil rights to people in prison and advance housing, disability, and economic justice. What we do here is a lot. I just started working almost like a year ago. I've been knowing about Uptown People's Law Center a long time, and I am so excited to be a part of this organization. What we do here, we provide representation to prisoners that denied their basic human rights, tenants facing evictions, and individuals seeking Social Security disability income. We have a nice team here, and they put in a lot of work, and I'm so glad to be working also. Who am I? I have this strange problem with believing that people know who I am. Like my brother Renato Hudson, he says that he needs a therapist for his ego. I think I'm in line with that too. I'm Stanley Howard. I'm a prisoner advocate here at Uptown People's Law Center. I taught a lot of people criminal law on the inside, and I'm so happy to be working here. And this is my coworker, Alyssa.
Hi, everyone. My name is Alyssa Meurer. I'm a staff attorney and Larson Justice Fellow here at UPLC. I just graduated from Berkeley Law last May, and I'm so excited to present. This is part of my fellowship project that I have created with the help of Stanley and his wisdom, and all of the staff at UPLC have supported in this project. So we're so excited to show you some of these guides and tell you a little bit more on how you can support your loved ones in IDOC.
Okay, prisoner rights practice. Why is this important? I'm sure everyone on this call have a loved one or is doing the work. And what we are trying to do, we are trying to share what we do here in order to facilitate any needs that you probably could help someone on the inside. So I know people that's on the inside is not a part of this call, but it's very important that we believe that you understand what we do here and how you could help people on the inside. What we do here is we sue the Illinois Department of Correction for unconstitutional prison conditions. That is a must. And that's the lane that Uptown People's Law Center been into for a lot of years. We also receive a lot of prison mail from people on the inside asking for help, almost on average between 50 and 100 letters per week. Our co-worker, Maurice Hughes, and I, we go through a lot of that mail, and we have a strong team that also does this work. And we have a policy here that every letter, let me say that again, every letter get responded to. How could we how could you support your loved ones? We do a lot of support for the loved ones and attorneys.
So popping in here with the legal caveat, we take confidentiality really seriously here. So one of the policies we have is if you have a loved one in custody, we do need permission from that person to talk with anyone about them. So any potential clients, we would love for them to mail our office and give us permission to share their information with folks. That's one thing that we're going to ask you if you contact our office. So just letting you know upfront.
Yes. what, why is this material so important? Pro se material. It's important because a lot of people on the inside need help and they don't have the right to attorney to start seeking relief that they need about the unconstitutional oppression that they are dealing with on the inside to file these civil rights cases. Like I just mentioned before, we receive a lot of mail, and unfortunately, we cannot help every individual. So we want to be able to help them help themselves by knowing what they have to do. We all know that the law library on the inside is inadequate and inaccessible. And we know this about what's actually going on with Logan right now, where we just heard that they have basically no law books there in the law library. Prisoners have a lot of reasons to file lawsuits. And if they are not on the front line of doing this work, a lot of this stuff do not get redressed. I'm looking at this picture with this guy with this typewriter. And this is the work that be done on the inside. I had one of them typewriters for years and tried my best to continue to fight the IDOC as much as I can and help a lot of people on the inside also. I've done 39 years of incarceration, 16 years on death row. And I fought them people tooth and nail with a typewriter just like that. And they're going to let me out and thinking that the fight is over with? No, it's not. The fight is just getting good. And I'm here at Uptown People's Law Center using this as my springboard to continue doing the work that I've been doing for the last 30-some years. People help people a lot on the inside. I taught a lot of guys criminal law as much as I know about criminal law and done a lot of help. We all are on the front lines too. What I mean by that, we all have a lot of loved ones on the inside. And this is my passion, and this is what I love doing. I tried to explain this to my wife a little while ago, that I was married before I was married. She asked me what did I mean. I was married to the movement, and I'm still married to the movement. Okay. Here's an overview of the prison material. Please, Melissa.
Absolutely. So here's an overview of some of the materials we have so far. So we have an updated guide on filing grievances, a guide on how to file a federal civil rights lawsuit from prison, and we have some know your rights guides on this kind of areas of the law. So one of them is medical rights. I'm one of the attorneys working on our class action Lippert, addressing the medical care systems in IDOC. We have a guide on excessive force and the law around that and the out of cell time. Other guides are to be announced, they're in the works, and we also have Spanish translations incoming. Our grievance guide has already been translated to Spanish, but we're hoping to have all of these guides available in Spanish to access those folks that have limited English literacy. And one little disclaimer for this whole presentation, this is not legal advice, so it's not going to be tailored to any specific case. There's going to be some nuances to each case that differ from maybe what I'm saying, but I'm hoping to provide just some general legal information about like what is the status of the law, what are people's rights, and so it's really important just to do a little bit of research beyond this.
Yes, I like to add in a little bit to that too, because by me helping a lot of people on the inside, I always let them know that this is not advice because they're not my client. This is only a suggestion because you don't want to open the door for any legal malpractice, if you will. So that part is very important. Thank you.
So all of these kinds of issues really stem from this one law, the Prison Litigation Reform Act, the PLRA. It was passed in 1996. The idea of the PLRA was to reduce prisoner lawsuits. So post-civil rights movement, there was a big influx, not only in the prison population, but of folks in prison using the federal courts to access their civil rights and to fight for their civil rights. Congress believed that there were a lot of frivolous lawsuits filed by prisoners. And so they created this law, the PLRA, in order to reduce the amount of frivolous lawsuits that they believed were happening from prison. So in order to do that, they instituted a bunch of barriers, including what's known as the exhaustion requirement, you're required to exhaust your administrative remedies before you file a lawsuit. In Illinois, that is the grievance procedure, which I'll go into in a little bit. You have to essentially exhaust your grievance procedure before you can file a lawsuit. Otherwise, you will just have your lawsuit denied right away. There's some more strict laws on filing fees. One of the things I'll talk about also is under the PLRA, folks in prison who are filing lawsuits have to pay a filing fee. There's no waiver for those fees. The PLRA also limited attorneys' fees. So there aren't that many attorneys doing this type of work, and it makes less of an incentive for attorneys to take on the work because their fees are capped at a pretty low amount.
Yeah.
And it also, sorry?
Yes, I'd like to touch on that, Alyssa, because this is very important. Because Joe Biden as the Judiciary Chairman and Clinton as president, they the one that signed this law into effect, and it basically limited the amount of lawsuits that's being filed by prisoners, because at this time, attorneys had no problems taking on these cases, but they lowered the attorney fees so low that most attorneys don't even want to take these cases anymore. And this is why a lot of people on the inside have to start the process themselves in order to get this ball rolling to attain the remedy and relief that they are seeking. Now, why is this important? Because judges do not allow prisoners the right to have an attorney. They want you to go through this long process and hope that you default in some kind of way and have the petition or complaint dismissed before we get back to trial. And then sometimes they appoint an attorney. But it is a hard fight to get there. Please.
Yeah, absolutely. And the last thing that PLRA did is, well, one of many, is limited the types of systemic changes that we can make to the entire system of prison. There's quite a few legal hoops you have to jump through to do that. So all of those were meant to reduce the amount of litigation that was coming outside of prison. As a result of this and all the procedural barriers that happen, less than 1% of prison cases nationwide are successful. So that's one of the reasons that we think these guides are so important, to let people know about the procedural barriers, to help them navigate them, and to know upfront how hard of a battle it's going to be to file these cases. So I'll start with a little overview of our grievance guide. There's an image of it right here. It's already available on our website, and we have already sent it to hundreds of folks inside. Grievances are super important. They are meant to give IDOC notice of people's issues and to give IDOC time to fix it before you file a lawsuit. That's kind of the theory behind it. We know that sometimes grievances don't work, and often they're denied for a whole slew of reasons, and it is really frustrating. But all of these steps must be completed before any lawsuit is filed. So it's really important that your loved one on the inside is filing grievances if they're having issues. It really documents the issue. There's 3 key steps to filing a grievance. First, they'll submit it to their counselor. They'll get it back with a signature. They'll submit that signature to the grievance officer. The grievance officer then submits some recommendation to the warden of the facility. The warden will send that back with a decision to the person in custody. And then the person in custody will have to appeal by mail to the Administrative Review Board in Springfield. The address is on the back of our grievance handout. Grievances must be submitted by the person in custody. We've gotten into a little bit of trouble trying to help people file grievances. Really, they're meant as an internal procedure for the person in custody to fill out the form, which should be available in their housing unit, and to submit it to their counselor, their grievance officer on their own. So what we recommend to folks on the outside is you can help people maybe think through the issue. You can help them kind of keep track of facts if you're familiar with the story that's going on, but they really ultimately have to fill out the form and submit it. There's some important deadlines you need to know for grievances. There's a pretty tight turnaround. After the injury happens or whatever happens that the grievance is about, there's 60 days that of a deadline that the person has to follow to file the grievance with their counselor. Once they get the counselor's signature back, they have 30 days to file that with the grievance officer. There should be a special box in the housing unit for grievances. they'll get the warden's decision back. They should file it with the administrative review board within 30 days after they get the warden's decision. These deadlines are very strict, and sometimes people's grievances will be denied just on the basis that they didn't file it on time. And so that's really frustrating. And another piece of that is IDOC does not have strict deadlines to respond. They have a pretty loosey-goosey, under the circumstances when reasonably feasible standard. So if there's a long delay, we recommend that folks first ask their counselor what happened. Sometimes the counselor will know or say, oh yeah, I need to go, check up on that. Or folks can file a new grievance saying, I filed this grievance on X date, I didn't get a response back, now it's been 4 months. And sometimes that will get the ball rolling to get the grievance process a little faster.
Yes, I agree with that because, sometimes grievances all of a sudden get lost and, they don't respond in a reasonable time and the clock be ticking and they know this sometimes, whereas they do everything in the world to try to deny you your right for relief. So this is very important to make sure that they always make sure that the timeline is exact because they are strict on this timeline.
Right. So we recommend when folks file grievances that they make a copy for themselves. They can either photocopy it or they can handwrite a copy. And then also take notes on important dates and deadlines. So when they file the grievance the first time, if they don't have a copy of it with the date on it, write down what the date was. If you ask your counselor what happened, write down the date. Just so there's some sort of timeline so you can keep track of when the deadlines are happening, things like that. So moving on, once you file your grievance, once you submit it to the ARB, you get a response. Likely it has been denied in some manner. Then you can start filing a lawsuit. So you're going to have to bring together some paperwork. This is a little screenshot of the guide that we have online. To start a federal case, you're going to need these 3 documents. You file them in one envelope. You can get the documents from the law library in most of the facilities, or you can mail the court for a copy of them. And they're also available online. If your loved one needs a copy, you can print it out and send it to them. You'll need 1 copy of the complaint form. We recommend keeping a copy for folks to keep a copy for themselves as well. There's a filing fee. The filing fee is $405, which they can submit by money order or check to the court. Or I'll get into it a little bit later, but there is a way to have an installment plan, a payment plan for the filing fee. And then the third step is notice to the defendants that they have been sued. You're going to have to let them know in some way. Different courts do it differently. So in the Northern and Central districts, there's a form called the USM 285. That's a formal Marshal Service summons form. You just complete it for each defendant. You put your name, you put the defendant's name, the address of the defendant's facility. These instructions are in the guide. The Southern District will do that stuff for you, so that's really easy. Page 6 of our guide has a list of facilities and the corresponding federal court districts and the addresses for which court corresponds with which facility. You need to make sure you're in the correct one for where the incident happened. So some tips for filling out this first complaint form. The plaintiff is the person who's filing the lawsuit. They're complaining, plaintiff, and the defendant is the person you're suing, who is usually an IDOC staff person or a medical provider. There's a section called the statement of the claim, which is the chance for someone to write what their story was, what happened. We recommend writing the facts in order of how they happened. It really helps judges kind of see a timeline and read it kind of as a story with a beginning, middle, and end. There is no need to sound like a lawyer. There's no need to use fancy legal jargon, fancy words, and there's also no need to cite to any cases.
Yes.
Stanley, did you have thoughts
Yes.
on that?
Yes. I'd like to touch on that also. When I was teaching criminal law on the inside, on death row and in prison, I always tried to make the people know that you don't have to sound like a lawyer because the direction that everything is going in is plain language. Now, if a judge wants to know what the law is, he have a law librarian in his office or in his chambers. Or if he need even more assistance, he could just ask a law clerk. So, they don't have to sound like a lawyer, just plain English, because what I always said that the judges always want to know two things. What do he want me to do, and why do he want me to do it, or she? And the plainer you can make that, the better.
Absolutely. And then the other part that you need is the relief requested, and that's what you're asking the judge to do. There's two things you can ask for. You can ask for both money or a court order. So there's two types of money. One is compensatory damages, which is paying for the harm that you suffered. And then there's punitive damages. This is what judges will order as punishment for particularly egregious behavior, really malicious behavior. And then there's injunctive relief, which is a court order. The court can order IDOC to do something, to stop doing something. And you can ask for both money and injunctive relief. That is absolutely an option. So you'll write that down in the relief requested. And then there's a box asking yes or no if you want a jury hearing. We always recommend that you check that box yes at the beginning. If you don't do that, you might waive your right to a jury, and you can always decide later that you don't want a jury hearing. So all of this is in the guide as well. And then I wanted to dig in a little bit more on the filing fees. So the filing fee is $405 for the federal courts. There is no fee waiver for prisoner lawsuits. That is because of the PLRA that I talked about earlier. However, if folks inside can't afford to file this, to submit this $405 fee, they may be eligible for a payment plan. So they'll have to submit what's known as informa pauperis form, or an application to proceed without prepaying costs. It'll be part of the packet that folks get from the court. It's available online as well. And what they'll need, the payment plan is calculated from their IDOC trust fund. So they'll need a statement of their last 6 months of their IDOC trust fund account balance, and they'll need that to be signed off by the trust fund officer. That should be attached to this application. So the judge will look at it and decide whether or not to allow a payment plan. It's up to the judge to decide this. Nobody has a right to a payment plan, unfortunately. When they do decide it, they'll calculate it. They'll look at the amount of income that comes in every month to the IDOC trust fund, and they'll look at the average monthly balance in the last 6 months. Whatever is higher of that number, they'll take 20% of that per case, and that is how much is owed. That money is automatically taken out of the trust fund to go to the court to pay them until the full fee is paid off. And then at the end of the case, if a case is settled or if there's a money judgment, whatever is left of the court fees will be taken out of that automatically.
Yeah, this is somewhat really bad because a lot of people don't have this kind of money, and they don't want to have money taken off their account that they can't afford in order to be able to seek the remedy and relief that they need. So that $400, $405 is a lot of money. Yeah,
it absolutely is. And I think it's important for folks to know, if you're putting money into people's trust fund accounts, that it might be automatically gleaned to take to the court. So this 20% adds up per case. And I think it catches people by surprise sometimes. So we just wanted to be really upfront about that. That's the filing fees under the Prison Litigation Reform Act. So the question is, what next? We often get asked, what if I need a lawyer to help? I think that's a fair question. There's one thing you can do is, at any time in a lawsuit, you can submit what's known as a motion for appointment of counsel. That requests a judge to appoint an attorney for the case. It's up to the judge's discretion because you don't have a right to an attorney in civil rights cases. And one of the things you'll need to do with this motion is you have to attach proof that you looked for an attorney on your own. So you need 3 basically letters saying no from law offices. That's one of the things that we do when we answer prison mail. We send out no letters quite a bit, unfortunately. But if in the process of starting the lawsuit, folks in custody can write to UPLC asking for representation, and we'll send them a letter saying, no, we can't represent you, but you can use this as evidence that you tried. And the judges will look at that and consider it when they decide whether or not to appoint an attorney.
Yeah. This goes back to what I was saying earlier about the appointment of counsel. I mean, a lot of people do not get the representation that they need on the inside, and they end up defaulting or having the lawsuit dismissed because they don't know how to maneuver around this. And this is one of the importance of having this webinar, to let everyone know what is required and what is needed. So the judge allowed a lawsuit to go all the way up to basically the last moment before the jury is paneled, and then appoint your attorney. By that time, mostly 95% of most of these cases are dismissed because guys do not know how to maneuver unless they have someone on the inside to give them a lot of assistance.
Right. Yeah, and so that's why research is so important. So after the filing, the court will submit an order with next steps. The court has no real deadline for this, and sometimes it'll take up to 6 months or maybe even a year for the order to come back. But that order is super important. It will have important deadlines. It'll say how much money is owed. The deadline for money to be owed is really important because if the filing fee is not paid when the judge orders it, sometimes the case will be dismissed, and the money is still owed. So that's really an important piece. It should go right to that person in custody if they're still in custody. And absolutely, when you submit the complaint, or even before you submit the complaint, it's time for research. There's a lot of resources you can look for. A bunch of resources are listed in our guide. I really recommend the Jailhouse Lawyer's Handbook, which you can see at jailhouselaw.org. You can access that from your computer. You can request a copy for folks in custody from that website, and you can also print it off and send it to them if you have access to a printer. The other really important pieces that folks will need to read if they're going to pursue a lawsuit is the local rules of the court. Each court website, it's the Northern District of Illinois, Central District of Illinois, and Southern District of Illinois. They all have their own local rules. So those are helpful to read. And so are the federal rules of civil procedure and the federal rules of evidence. They get quite complicated, truly. So research is really important, and kind of knowing what you're getting into with these cases.
The Jailhouse Lawyer manual is really important. And if I had it my way, one would be in every cell. And if you could download this for free and send it to the people on the inside, please do so. Flood the prisons with this material.
Yeah, they're absolutely helpful. So I'm going to take just a really quick break for folks to kind of let that sink in. If you have questions, please put them in the chat. We might have time for like 1 or 2 hands if you have like immediate questions.
Can you hear me?
Oh, yes, we can hear you.
Okay. My name is Khalif. I tuned in somewhat late, but I come to support your program because I experienced Mr. Stanley Howard's adventure. You know, I came home in 2021. I did 51 years.
Wow, congratulations.
Went in as a 17-year-old kid, you know, wrongful conviction, and I fought tooth and nail for a police murder. So I get the process. A lot of times, like you said, we can't get the support we need to filing. I had to learn jailhouse lawyer, jailhouse terms, statutes, research on my own, like the next man, because it's a learning process and you're fighting for your life. Nobody fights better than yourself when you know what the odds are against you. And in that research, we also find ourselves needing the help of an attorney. Like you said, often we get caught in research, we get caught in, you know, statutes where we don't understand, and you're trying to file a motion, that deadline kills you a lot.
Yeah.
Alternatives is a situation we always try to adapt. What is our next move? How do you educate the next man? So through trial and experience, as jailhouse lawyers, we teach one another.
Absolutely.
Now, even though being removed a couple of years from the situation, I have friends and, you know, associates that we have fought tooth and nail with, tried to bring home now up under these C numbers situations. And finding pro bono help is so critical now because no one wants to touch a cold case.
Yeah.
And I'm sure that you ran into that same case scenario, Mr. Howard, when you land up there trying to clear your position before you learned law. No one wanted to touch your case because it's a cold case.
Yeah, and I like to say that's the importance of what we are trying to do here. Try to share this knowledge far and wide. I appreciate you, Johnny, man, and I'm so glad that you're at home. 51 years, that is a long time.
Yeah.
Thanks,
Thank you for
Johnny.
sharing.
Yes.
Uh,
Okay.
We'll have some more time for a question and answer at the end of this session too. And we'll have a survey at the end also for you to share your thoughts and experiences. So yeah, thank you so much.
Alyssa and Stanley, there's also a question in the chat about if these resources will be on the IDOC tablets.
No, unfortunately, the IDOC is not in the business of helping people fight the IDOC. Unfortunately, they are in the business of keeping people in captivity, keeping people locked in cells, and this is not a part of their agenda. And unfortunately, it would not be on the tablet. And this is why we are sharing it here, whereas you could probably download the material and send as much of this material on this side as possible.
Exactly. Yeah. We're going to see if we can contact some of the law libraries and see if we can get them spread more. But I think that is probably true that we might not be able to do that. Alrighty, moving on. I'm going to dig into some of our Know Your Rights guides. So on our website, we have 3 already. We have Know Your Rights guides on medical care, excessive force, and out of cell time. In progress, we have some on failure to protect, religious rights, and due process, especially about discipline. And we have more topics to be announced. We have absolutely a lot of mail coming in. We know some of the issues that are coming up. So we're working as hard as we can, making some more. But I will dig into the ones that we have ready so far right now. So medical care, as you may know, UPLC represents everyone in IDOC custody with serious medical or dental care needs as our class action case Lippert. I'm one of the attorneys on that case. So that's our little background knowledge. IDOC has a constitutional duty to address the serious medical needs of people in their custody. There's 2 legal questions to kind of get to a medical care case. The first is the person has to have a serious medical care need or serious medical need. There's 2 ways to define that. The first way is just having a condition diagnosed by a doctor, so having a serious diagnosis. And the second one is if it's a medical issue that is so obviously in need of treatment. So like if someone has a broken bone, I don't think anyone would argue that that is not a serious medical need. So either a doctor diagnosis or just something common sense obvious. The other legal question you have to show is basically fault. So you have to show deliberate indifference by the defendant. There's 2 steps here. First is that the defendant knew of the risk of serious harm. This is where the grievances are so important because it gives IDOC notice of the harm that is happening. And then you have to prove that the defendant intentionally failed to help. So the kind of personal involvement of the person you're suing is really important. So keeping track of all the communications you've had with folks is really important. We also recommend that people take notes, especially with the medical care stuff, because it gets really complicated. So any communications they had with staff people, whether that's correctional officers, counselors, or medical staff, all the medical appointments, writing down the dates is really helpful. Anytime they made a request for medical attention, writing down the date, who they talked to, what they said. And that's the same for folks on the outside. If you did advocacy, if you talked to constituent services, if you talked to, if you called the facility, write down the date that happened, write down who you talked to, what you said. It also helps to have it in writing if you write it in an email. And the other thing outside advocates can help with is kind of keeping track of these notes, keeping track of the appointments. If you have a loved one inside, you may know that sometimes paperwork gets lost or destroyed, or who knows what happens to it. And so it can also be helpful if folks on the inside have someone on the outside that they can send original paperwork or notes to, that you can make a copy and then send them back the original or send them a copy, just to make sure that that paperwork isn't lost and they can still reference it in the future.
I know we are probably speaking to the choir at this moment because we all know that healthcare on the inside is really bad, and they do everything they can to try to squeeze and save a dollar here and there. And how they do that? By denying you as much healthcare as possible.
Yeah, very frustrating. We're working on trying to fix the system, doing what we can. It's slow moving. The next topic is excessive force. So this is an issue that came up in our Orange Crush lawsuit. Ross recently, there's a photo of Orange Crush here. The key question in these excessive force cases that judges will ask is whether force was applied in good faith to impose discipline and maintain control of the facility, or just to cause harm. I think the legal standard is called maliciously and sadistically to cause harm. Just large words basically saying people are just out to get you, out to hurt you. Judges obviously can't read the minds of guards or people who are committing harm, and so they'll consider several factors. One of the things they consider is how the level of injury, how the person was injured. They'll consider the need for force, whether there was some sort of a scuffle or dispute, if there was a safety concern, was force needed. They'll look at the amount of force used and kind of in relation to how much it was needed. So like if I'm trying to get someone out of their cell, kicking them in the face doesn't make any sense. So they'll kind of look at that and they're like, that doesn't add up. They'll also ask whether the threat to safety that the officer, whoever committed the wrongdoing, whether they perceived this reasonably. So they'll put themselves in like the officer's shoes, for example, and say, okay, was it reasonable to think that there was going to be a safety threat here? And then the other thing judges will consider is any efforts that were meant to de-escalate. So whether there were warnings given or kind of lesser amounts of force used before this extreme amount of force was used. Those are kinds of the things that the court will consider. So in kind of putting forth the story of what happened, it's also important to think about those factors and explain there were no efforts to de-escalate. They didn't give me a warning, things like that. So that's kind of how to work with these legal standards.
Yes, don't forget that we are not blind to the fact that even in 2025, officers on the inside are getting away with beating people up with impunity. No doubt about it. And we all hear these stories all the time. Me and Maurice, we hear this story all the time in prison mail, asking for help. This officer did this, and there's really no backlash for officers doing this mess. And it's got to stop. And the only way that we be able to do this is continue to try to hold those accountable with what they have committed. So yes, this is important.
Absolutely. The last guide I'll talk about is our guide on out of cell time. It's frustrating. There's no right to any specific amount of time spent out of a cell. We know that confining people into cells for long periods of time, long-term solitary confinement, is really damaging and harmful. Unfortunately, there is no law that says that you have a right to a specific amount of out-of-cell time. However, the Eighth Amendment prohibits cruel and unusual punishments. And so the way to kind of get around this is some cases have been successful when they said the prison was engaged in a serious denial of my basic human needs. Basic human needs are food, water, shelter, right? Also exercise, social time with other people. Human beings are social creatures. We need to be around others. And so if you can show that you had or someone in custody can show that they had an extended amount of time with no exercise, with no social time, they weren't able to interact with other people, that might be a way to kind of get this in the court. One of the requirements of the Prison Litigation Reform Act that I didn't mention earlier is this physical injury requirement. This kind of is really important here because most of the injuries that happen with long-term solitary are mental and emotional. Mental and emotional injuries are not enough to get a lawsuit successfully into court. Because of the Prison Litigation Reform Act, you need to show that there was a physical injury. So that is some sort of bodily harm that you're facing. So list any kinds of physical symptoms that have happened. That could be headaches, it could be fatigue, it could be muscle weakness. We go into some more also in the guide. But basically anything that you notice is happening to the body, could be evidence of a physical injury. So it doesn't need to be like broken bones necessarily. And then the last piece that you need to prove is deliberate indifference. It's the same standard as those medical care cases. You need to show that the defendants knew that there was harm happening and that they intentionally did nothing to help or to fix it. So that's another piece where the grievances are really important because they are proof that the defendants knew about it. This one other piece is what I would say, watch out for safety and security concerns. Sometimes cases will lose because prisons will say, well, this person was a safety risk, a security risk. We couldn't let them out of their cell. They're going to hurt someone. And so that's just something to watch out for as a defense that the prison might come back with.
Yeah, I like to say, yeah, there is we have a statutory right to out of the cell time here in Illinois. I think it's 6-7 hours a week, but there's no constitutional right to out of the cell time. But they also are now, they call themselves having this shorter staff that us here at UPLC do not use the term shorter staff. We use the term that there are too many prisoners. If they start letting more prisoners out, then they won't be so-called shorter staff. But having people being locked inside these cells 20, 21, 22 hours a day, every day is a form of torture. We know this about the Nelson Mandela rule from the UN, and we also know this from Unlock the Box. So this is very important that people fight to have their right to out of the cell time. Yes, it is.
Absolutely. And yeah, this right is not in our state law. We don't have a right in our constitution. We do have a right in our state law, but you can't sue in federal court over a lot of state law violations. It gets a little complicated there.
Yeah.
So how you can support. One of the things that we would love is to have these materials be shared far and wide across Illinois. Some of them apply to other states too, but absolutely focus in Illinois. Have your loved ones contact us about the conditions they see in IDOC, what's going on. We have our address right there. We read and respond to every single letter we get. We can't always promise that we can individually respond to each letter because we get so many. But part of the project of making these guides is making sure that we have something useful to give to people when we're responding to their letters. And then there's some other people you can contact if you have issues. The constituent services or family liaison at IDOC is sometimes helpful. Sometimes they can't fix the problem, but they are required by state law to document and log every issue that comes to them. So when there are patterns of bad things happening, especially in certain facilities, they'll have a record then, and they give that to the legislature who can make policy. So it's important to talk to the family liaison, even if they can't solve your problem, it does get documented somewhere. Sometimes people will advocate for their state representatives, and that can get the ball rolling. State representatives sometimes have access to the wardens or can send an email or call or do some advocacy on behalf of their loved ones inside. So don't discount contacting your representatives. And then the other thing is we have a survey that we will send out to anyone who attended. Look out for that in the next week or so. Just to get your thoughts on the webinar, the information that we gave, other topics you would like to see. That would be super helpful for us. And yeah, thank you for attending. I think now is time for question and answer.
Thanks, Alyssa and Stanley. You did a wonderful job. I'm so proud to call these two individuals colleagues and fellow advocates. We have a question. Is UPLC inside of IDOC prisons and jails?
Well, no. Unlike John Howard Association that has access to people on the inside, we, in my mind, we fight against them so hard. And the last thing in the world, they want to have UPLC snooping around or having their material on the inside that could actually hurt their agenda. So no, we are not on the inside, but we are trying our best to make sure that we are. And this is how you all can help, by flooding the prison with this material. This is something that the IDOC really do not want. Please help us flood this, the IDOC with this material.
Absolutely. And the other piece of that is we do our work pretty much exclusively against IDOC. Our lawsuits are against IDOC, and we don't do work in the county jails. So that is our practice area, is the prisons and not the jails. Although some of the same constitutional rights apply in jails, sometimes you have more protection, especially if it's pre-conviction. But we don't specialize in that, so we can't give a lot of information about that.
Yeah. And I'm also happy that we are, not only filing lawsuits against the IDOC, we are in the process of getting in many other lanes also to make sure that we are part of the fight and stand on the front line with our other sisters organizations also.
Yeah, and if folks contact us about 4 to 6 months before they're released, if they're eligible for Social Security disability benefits, we do have a program that facilitates the release to make sure people get their benefits on time. So that's another practice area we do. And we also work under the Just Housing Amendment to make sure that Cook County, folks in Cook County are not discriminated against based on their criminal records. So both in and out, we're doing advocacy.
Stanley and Alyssa, what is the most common type of request for help we receive from someone in prison?
Please, the number one thing that me and Maurice and the prison team receive, the letters are about healthcare and asking for assistance and attorneys. And it's impossible for us to represent everybody, and it's so sad. I mean, reading these letters is complicated. We go through it with a fine-tooth comb, and that's some of the most, heartbreaking things that I have to deal with, but it's part of the job. And, we just cannot help everyone. This is why we are doing this webinar, and this is going to be a series that we make sure that we are letting everybody know that's standing on the front line with us, how to help those on the inside.
Thanks, Stanley. And there's a question about, from an attorney representing prisoners for healthcare issues. How prevalent is retaliation against a prisoner for filing a lawsuit? And then their second question is, if a cell is tossed and property is taken, where can they get their legal papers back? And is there an inventory that must be taken so they get all their items back?
Well, I'm sure Melissa could probably speak on the medical part of it. But personally, I know for a fact that when Orange Crush and these cells are tossed, there's no remedy, because you have to be able to prove that you had this and you had that, and there's no pictures. So some of these officers, they go in with the agenda to somewhat destroy as much material as possible. As far as retaliation for filing lawsuits, if it's against certain individuals and those individuals have able to retaliate and have contact with them, they may not even do it directly. They may do it indirectly by having their cronies, their friends, or their cousins who's also part of the staff to be able to do it. So you can't be able to say that it was personal and it was a part of retaliation, but it's something that goes on all the time. And I'm sure Melissa probably could speak about the medical part.
Yeah, I just wanted to add that retaliation is somewhat common, I would say, and it can be from different scales. Like it could be from like making someone like go to the end of the line for chow, or like skipping them over for something, or it could be like little comments, or sometimes we've seen more like physical assaults or stuff happen. So retaliation actually absolutely does happen. I think it kind of depends on the circumstance and the person.
Yes, and that's a constitutional action also. That's a constitutional action, yes.
Yeah, there's a First Amendment retaliation claim, because people do have the right to file a lawsuit. They have a right to file a grievance. And so if in response to that, they're getting retaliated against, there could be a First Amendment claim.
There's a few more questions in the chat. Can you speak on the best way for someone on the inside or outside to support documenting an injury that occurred due to excessive force so that it can later be referenced in a grievance or lawsuit?
Yeah,
Yes,
I mean, I think
please
the
go ahead.
easiest way is to seek medical attention. If it's possible to file a sick call pass and get, especially if there are any kind of physical markings, bruisings or something like that, that there'll be documentation then of that happening. Otherwise, writing down exactly the date and time, where it happened, who was there, who were the officers that witnessed it, who are other individuals in custody that witnessed it. Those are the kinds of things you want to think about, like just what exactly is going on, who can I turn to as a witness that saw this happen, and like when did it happen and what was happening around that? What are the kind of circumstances? Like, was someone alone? Were they like arguing with someone? You know, those kinds of things I think are really helpful to document.
Yes, because that goes along with what we know. It's not what you know, it's what you can prove. And documenting everything is very important.
I see Julie Anderson, I see your question. How many pages is the guide? The grievance guide is 1 page front and back, and the how to file a lawsuit guide is 3 pieces of paper, it's like 6 pages total, but 3 pieces of paper. And we did that on purpose, so you could send both of those, that's 4 pages in 1 envelope. I think you can have 4 pieces of paper in 1 envelope with 1 stamp.
I think Bill might be restricted to 3 right now, but I'll follow up and see. Then you could do
Okay.
separately, I guess, you know, which
Yeah.
would be. Thanks. I was afraid it was really thick.
No, it's
Yes.
not. The jailhouse lawyer's handbook is, but we were trying to make it really short and streamlined as much as we could. And the
Yes,
guides
Julie.
are 1 to 3 pieces of paper.
Yes, we heard about that complaint about the IDOC is trying to limit the number of pages in
Yeah.
each particular envelope. Like if you want to send in 20 pages, you have to send 3, 3, 3, 3. That can get very pricey also, especially if you're trying to send a lot of paper in. It's just ridiculous.
And it's you know, typical of each facility is doing who knows what. So,
Yeah.
you know, they're all
For
different.
sure. Right.
Thank you.
I have a question.
Yeah, go ahead.
My name is Anna, and I don't know if this really relates, but can you tell me the difference between the PRB and the parole board? Illinois doesn't have a parole board, correct?
No,
Correct.
So
just for
what-
those that
what-
have C
what
number
would a-
prisoners.
Go ahead.
The parole board is just for those C number prisoners that was sentenced before 1978. The prison review board is somewhat to, handle clemencies and other cases like that. It's a big
So,
difference. So no, we do not have we don't have a parole system here in Illinois. It's MSR, mandatory supervised release.
so a parole board, if we had one, would be a board that would review these cases individually to see if they could somehow get some time off or whatever.
Yes,
Is that correct?
yes. They would be
So,
able to assess each individual to determine whether or not they're eligible and qualified for release.
so then right now we have people after they get out, they go on parole,
No,
right?
they go on MSR, mandatory supervised release, and it's part of the sentence. Sometimes it's 1 year, 2 years, or 3 years.
Oh, okay. So that's not really called parole
No, it's
anymore?
not. No, it's not.
Just want to,
Okay.
I know there's a few more questions in the chat, just in the time we have left. There's a really good question about, recognizing that IDOC's trying to avoid lawsuits by making the inmates miss timelines, by not acknowledging grievances and not respecting their own timeline for moving through the process. What can we do to combat that?
I think my main advice is make copies of all grievances that are filed. Write down the dates when folks file them, and if they can nudge their counselors and say, please, like what happened to my grievance, or if they didn't get you're supposed to get like confirmation number in the mail, in the institutional mail. If they don't get that, kind of bugging their counselor about that. Yeah, I think making copies, and then if they don't get a grievance, if they don't get that grievance back, filing another grievance and saying, okay, I filed this grievance on this date, I never got a response. That can also document that there was a delay. And then, yeah, the other thing is just these timelines are really kind of loosey-goosey for IDOC. And so I think they honestly have to wait. But if the grievance process is truly unavailable, that is something that they can argue in court maybe, because that is one of the exceptions to the exhausting administrative grievances. But really, they just kind of have to wait and be patient. And during the time that it's pending decision, that is when this gets a little complicated. But the statute of limitation tolls, and so their timeline for filing a lawsuit might get a little bit extended because of that. So I know that's something folks worry about. It gets a little more complicated than that, though. So I don't want to say any kind of sweeping statements. Yeah. But really, like keeping track of things, keeping those dates, and being on top of requesting assistance and requesting a reason for the delay.
Yeah, there's no doubt that the IDOC have this unwritten policy to try to stop you from filing grievances and make it hard. And timelines are really important. So they have an incentive to try to stop you in many different ways. So yeah, keeping track of everything and staying on top of the IDOC to make sure that you are receiving response in a timely manner. That's the key there.
Hey, Stanley, I put in the chat and I was trying not to just jump in. That I had two questions. This is Jasmine Smith. I want to thank y'all for this webinar, very informative. I did screenshots and information for a lot of the survivors that reaches out to me. Not sure if everybody was able to check out what I put in the chat, but Stanley, you familiar with me very well. I fight with my organization to fight to get the men and women out of prisons. We are having a meeting this Thursday for the ones who are interested and are still fighting for their loved ones to get out, to join that meeting. I put the Zoom in the chat. But also in my number as well for people to contact me. But I have a question in regards of like, and I was listening very well, the body cam. Now I heard about the lawsuits, the grievances, procedures and stuff like that. But Stanley or Alyssa, do you guys know of any organizations or yourselves that have tried to put forth the fight to get body cams, enforce body cams for those COs to wear in all of the IDOC prisons? And then also, if there are other organizations that are already fighting, like outside of what you guys are doing for the grievance process, or to bring awareness to the COs who are indeed like attacking our loved ones like on like racist and like they're slave masters and stuff, treating those inmates like that. Like, is there a process of other organizations that's taking a broader stance outside of just filing the lawsuits and the grievance process to fight against or bring awareness to these names and these wardens who are not doing what they're supposed to be doing to give justice?
Yeah. I'm sure we are tight on time here, but I thank you for all your work, Sister Jasmine. And yes, I had this conversation with our former executive director, Alan Mills, about body cams on the inside. This is something that's very much needed, but the fight is going to be really tough because it's also part of living conditions that's in there. People are actually living in there. They have officers walking around with body cams in this situation. I don't know how that's going to pan out, but it was part of the conversation that we have here, and we'll continue to do so. I'm sorry that we are pressed for time here, and I'd like to kick it back to Kate, please.
Thank you so much, Stanley and Alyssa, for this terrific webinar and all of this amazing information that you shared. And I'm just so impressed by the number of advocates and experts in their own right who showed up today. We really appreciate it, and all the information that you shared as well. There's more to come. We've recorded the webinar, so we'll be sending that out. Feel free. We encourage you to share that with your networks along with the materials. Thanks again. Have a great day.